Definitely yes. It is because the lawmaking ability of the judges and the power of judicial review is being used more often, especially since the 20th century. When you look into statistics, you'll find that in the 20th century, the justices very often reviewed constitutionality of laws being decided by Congress or by state legislatives. In whole, the Supreme Court has declared about 1,200 lower laws unconstitutional, which is a lot compared to, for example, 4 decisions of Congress, 4 amendments that changed the constitutional precedents of the Supreme Court. So you can see that this process of judicial review makes the institution very attractive from the political perspective. You could see that attractiveness in the process of appointment of justices. So the presidents are appointing lawyers who have political opinions, and the Senate is also politically oriented when they are confirming that people. On the other perspective, during the decision-making process, you can see that the institution of amicus curiae, which is called the friend of the court, is used very often, not only by US government, but also by interest groups, by many individuals who believe they can be a third party in many cases. The effect is they're trying to influence the adjudication of the court. Of course, the easiest answer would be that we need to wait, because estimation of every court is the best when the tenure of such court ends. Like, it's easier for us today to talk about rankless court than we talk during its tenure. Things may change. But things are changing right now. We could observe John Roberts Jr. taking the court in 2005, the Chief Justiceship, and being a moderate judge, a conservative, but not being very loud. I mean, you didn't hear much of Roberts. You heard more from Scalia, Thomas, or Ginsburg and Breyer. But today, after the NFIB versus Sibelius, the Obamacare decision, where it was Roberts who, surprisingly for many conservatives, found the law constitutional, many people asked themselves the question whether it was a politically oriented decision to somehow try to save elections for conservatives, as we see they did not succeed, or whether it was an individual approach of Roberts, not only in that case, but it was maybe a beginning to a new era of a court with a strong Chief Justice who will not be purely conservative, but who will define his ideology depending on the stakes of the case. Well, Barack Obama, as a Democrat and having liberal approach towards economic and social aspects of everyday life, tried to appoint also justices who had similar approach. However, his first choice had also some additional distinctive factors. He chose Sonia Sotomayor, a woman, but also Latin American, first Latin American to the Supreme Court. It was not Obama who tried to show that this factor was decisive, but Sonia Sotomayor, during one of the first interviews after her choice to the Supreme Court, said that she is sure that a Latin woman with her experience can make a good or even better decision than a white man, which shows you that this ancestry or ethnicity factor could be very, very important. The other choice was of Elena Kagan, a close political ally of Barack Obama, former Solicitor General, so an institution that is talking about law, but in a political manner. And the question is whether Kagan would be more a Solicitor General and a representative of government, or whether she would be a good justice, as she never held such a high judicial position. Obama had 2 liberal vacancies, and the effect are 2 liberal justices. So I think that he falls into the repetitive pattern that we could observe in history. Maybe in 2 years' time he will have a chance to have another vacancy, but we estimate it's also going to be a liberal vacancy, so probably after the end of his second tenure the court will still be a centrist court, 4 + 4 + 1.
Thank you very much.
Thank you.